Very good morning to all. The topic for today's lecture is Historical Perspective and Significance of Prevention of Corruption Laws in India. In history, many a scam has staggered and has been staggering the development and welfare of the nation. To preserve the progressive welfare of the state by preventing bribery and corruption, the lawmakers have thought of enacting anti-corruption laws in India and protect the system from the evil of corruption. The Government of India has enacted Prevention of Corruption Act 1988, which we will discuss precisely in this lecture. India's history is replete with countless anti-corruption measures and subsequent punishments. The Rig Veda, a sacred Hindu text described as the oldest literary monument of the Indo-European races, discusses the prevention of corruption and extortion. Vishnu and Manu punished people who accepted bribes and punished corrupt government officials with property forfeiture. During the British time, the British colonial rule saw its fair share of deceitful practices, but still Britain attempted to minimize such acts. During his tenure as Governor General, Lord Cornwallis, in contrast to Warren Hastings, implemented policies such as increasing East India Company servants' salary, prohibiting such servants from receiving presents, and opening the doors for the creation of the Indian Civil Service, whose purpose were to decrease corruption. In the 19th century, before the collapse of colonialism in India, Britain passed the Indian Penal Code to construct a proper legal criminal system. In the pre-independence period, the Indian Penal Code was the main tool to combat corruption in public life. The code had a chapter on offences by public servants. Sections 161 to 165 provided the legal framework to prosecute corrupt public servants. At that time, the need for a special law to deal with corruption was not felt. During the Second World War time, the war created shortages which gave opportunity to the scrupulous elements of the society to exploit the situation, leading to large-scale corruption in public life. This situation continued even after the war. So the lawmakers concerned about this menace felt that drastic legislative measures need to be taken. Hence, the Prevention of Corruption Act 1947 was enacted to fight the evils of bribery and corruption. The Prevention of Corruption Act 1947 did not redefine nor expand the definition of offences related to corruption which are already existing in IPC. Similarly, it has adopted the same definition of public servant as in the Indian Penal Code. However, the law defined a new offence, criminal misconduct in discharge of official duty, for which enhanced punishment, minimum 1 year to maximum 7 years, was stipulated. In context of burden of proof, in order to shift the burden of proof in certain cases to the accused, it was provided that whenever it was proved that a public servant had accepted any gratification, it shall be presumed that the public servant accepted such a gratification as a motive or reward under sections 161, 164, and 165 without the permission of the authority competent to remove the charged public servant. The Act also provided that the statement by bribe giver would not subject him to prosecution. Such provision was considered necessary to grant such immunity to the bribe giver who might have been forced by circumstances into giving a bribe. This immunity was not provided. If this immunity was not provided, all complainants would become liable for punishment which would deter them from giving complaints against any public official who accepted bribe. After that, in the year 1952, the Criminal Law Amendment Act brought some changes in laws relating to corruption. The punishment specified under Section 165 of IPC was enhanced to 3 years instead of existing 2 years. Also, a new Section 165A was inserted in the Indian Penal Code, which made abatement of offences defined in Sections 161 and 165 of IPC punishable. It was also stipulated that all corruption related offences should be tried only by special judges. Finally, in the year 1988, to mitigate the drawbacks present in the Acts of 1947 and the Amendment Act 1952, the Prevention of Corruption Act was passed by the Parliament. The Prevention of Corruption Act 1988 consolidates the provisions of the Prevention of Corruption Act 1947, the Criminal Law Amendment Act 1952, and sections 161 to 165 of IPC. Besides, it has certain provisions intended to effectively combat corruption among public servants. Some essential features of the Act are as follows. First, the term public servant is defined in the Act. The definition is broader than what existed in the Indian Penal Code. Second, a new concept, public duty, is introduced in the Act. The offences relating to corruption in the IPC have been brought in Chapter 3 of the Act, and they have been deleted from the Indian Penal Code. All cases under the Act are to be tried only by special judges. The corruption related cases will be tried by the special judges appointed for that purpose, and the regular courts will not have jurisdiction to try the cases related to corruption. The proceedings of the court have to be held on a day-to-day basis, so a speedy disposal of cases can be made out. The various penalties provided for the various offences are enhanced by this Act. The Criminal Procedure Code, for the purpose of this Act only, to provide for expeditious trial. Section 22 of the Act provides for amended sections of 243, 309, 317 and 397 of CRPC. Under the Act, it has been stipulated that no court shall stay the proceedings under the Act on the grounds of any error or irregularity in the sanction granted unless in the opinion of the court it has led to failure of justice. Also, other existing provisions regarding presumptions, immunity to bribe giver, investigation by an officer of the rank of Deputy Superintendent of Police, access to bank records, etc., have been retained in the present Act, which was also presented in the previous Acts of 1947 and the Amendment Act of 1952. If we consider the statement of objects and regions for the enactment of the Act, the statement of objects and regions expressly mentioned that the object of the Act is to amend the existing anti-corruption laws with a view to making them more effective by extending the scope and ambit of the definition of public servant, and to bring within its sweep each and every person who held an office by virtue of which he was required to perform any public duty. Thank you so much.